Good afternoon, everyone. Welcome to another Law and Technology Initiative event. My name is Linna. I'm a senior lecturer here in the law school and at the engineering school, and also the director of Law and Technology Initiatives. We have a great panel today on emerging trends in data privacy post-Dobbs. We've got Professor Matthew Kugler joining us, a professor here at Northwestern Pritzker School of Law. We've got Rebecca Wexler joining us, professor at UC Berkeley School of Law, and Cristina Messerschmidt, an attorney at Baker McKenzie and alum of Northwestern Law School. So just wanted to, just a little bit of background on the Law and Technology Initiative. This is a partnership between Pritzker School of Law and the Computer Science Department, the McCormick School of Engineering. And we're really focused on doing programs like this that help build the community. We want to connect with practitioners, with researchers across the space. So we're doing monthly meetings, academic conferences, training workshops, research, and then we have some courses that we're putting together in connection with the Law and Technology Initiative. So our agenda today, we're going to keep these opening remarks really brief. We're going to have 8 to 10 minute presentations from Rebecca will go first, and then Matthew Kugler will give his 8 to 10 minute talk, and then Cristina will be batting cleanup, and we'll hear from Cristina, and then we'll go into moderated discussion with the panel. And so what I really want to encourage you to do is to please use Slido to submit questions. So David's going to drop the link. David Scheckman, David and Elise Wu are working with us here on this program. But so grab that link to Slido, or if you're in the room here, you can just go to sli.do and use NULTI to join on Slido. This worked great for our event last week. So please submit questions there. We'll be taking those questions and using them in the discussion portion of the program. All right, so thanks again to our speakers. We're looking forward to some really great content and really great discussion today. And with that, I'm going to stop sharing here and turn things over to Rebecca Wexler. Rebecca.
Thank you, Dan. Thanks so much for organizing this. It's really wonderful to be here. I'm going to talk today about some work that I've been doing in collaboration with Aziz Hook, who's a professor at the University of Chicago, on data as evidence in the post-Dobbs era. So some of you may have heard on June 24th in Dobbs, the Supreme Court eviscerated the constitutional right to privacy, overturning Roe and unleashing a series of states to enact criminal prohibitions against abortion and civil penalties against abortion. 13 states had trigger laws to go into effect immediately when the opinion came down. Some of those states, Kentucky, South Dakota, Louisiana, contained exceptions for the life of the mother, but no exceptions for serious health impairments, and no exceptions for rape or incest. Other states, such as Texas, Idaho, Oklahoma, enacted laws that permit private citizens to bring vigilante civil suits against abortion providers and others who assist pregnant people in seeking abortion care. One difference between the current moment and the pre-1973, pre-Roe moment is the vast universe of digital data that can produce relevant evidence for anti-abortion investigations and prosecutions. So this data creates a kind of epistemic mirroring effect. Today, people who are pregnant and seeking healthcare are likely to start their search for care with digital technologies, with internet searches, by communicating with friends, family, trusted advisors via text message or social messaging apps. And in their quest to obtain information for healthcare, they are generating data trails that can be used by anti-abortion investigations. In the weeks following Dobbs, some of you may have seen, the media gave a lot of attention to a particular form of data, period tracking apps that can reveal the fact or loss of pregnancy. But in fact, this issue is far, far broader. It's location data, it's web search histories, text communications, it's commercial transactional records, also reproductive health records. All of these types of data can reveal interest in abortion, pregnancy, the loss of pregnancy, historical access to care, as well as prove or disprove rape allegations for people who have attempting to seek abortion care under a rape exception. Even before Dobbs came down, one woman was prosecuted criminally for feticide and another for murder following a miscarriage based on, in part, their web search histories and text message evidence. And after Dobbs, some of you may have seen at least one woman and her mother have been subject to criminal charges for an illegal abortion based on content of Facebook messages that Meta turned over in response to a search warrant. So given this landscape, what do we do about data privacy to protect pregnant people and those who provide them with care? There are a few things that major technology companies have discretion to do and should do, and small technology companies as well. The first best option is don't collect it, don't store it. Then don't volunteer it, and then challenge legal process. So what do we mean by don't collect and don't store? Well, if you don't have the data, of course, law enforcement can't come and get it. Civil vigilantes can't come and get it. One major technology company so far has made a promise not to retain, to immediately purge location data for people visiting abortion clinics and other sensitive sites like domestic violence centers. That's Google. Google made that commitment in June. But what they didn't do is a broader commitment to not collect data like keyword searches that could also implicate their users. Now, you might be thinking, why does it matter even if Google purges location data around abortion clinics? If I'm already a suspect and I'm traveling from an anti-abortion state to a pro-choice state to seek care, isn't somebody going to be able to infer from my vehicle location or other location information, cell site location information, that I'm on my way to an abortion? Well, yes. But what this can do is actually prevent law enforcement from using what's called geolocation warrants, or warrants where they will ask for all of the location data around a particular area without individualized suspicion. If Google would do the same commitment to purge keyword search data, then law enforcement would also be unable to use reverse keyword search data. Other companies should follow suit, but that's all that we've got so far from an existing promise. The next best option is, if you're going to collect the data, don't volunteer it to law enforcement. So obviously don't proactively send it to law enforcement. If law enforcement comes or civil litigants come, demand legal process. But actually this requires more still, because intermediary data brokers can pass along this abortion relevant data to law enforcement. So we saw Vice Media report in June that a data broker called SafeGraph, which obtains location data from cell phone apps, was selling the location, 1 week's worth of location information for every person who visited 600 Planned Parenthood locations around the country for just $160. And data brokers have continued to sell that location information for sensitive places. So don't volunteer the information to law enforcement, and also don't sell it on the open market to intermediaries who might pass it along. Finally, challenge legal process. Just because somebody comes with a valid warrant doesn't mean you have to roll over and comply. Big tech companies have a history of challenging warrants before they hand over any data. In fact, Meta challenged a warrant in a white collar criminal case, a warrant from New Jersey earlier this summer, and won. And so there's a history of companies pushing back against warrants. That's a good thing from any legal perspective. Warrants are issued ex ante with ex parte proceedings. And so that means that only law enforcement is present before the judge when they decide that a warrant's going to issue. It's not until after somebody receives the warrant or is target of a search that there can be an adversarial challenge to the warrant. And that adversarial challenge is important for ensuring lawful process. So this is within the bounds of current law for law enforcement for tech companies to challenge these forms of legal process when they come come in. If they do it regularly, it will raise the cost of anti-abortion investigations, chill some, slow others. Now, you might be thinking, wait a second, I don't want companies to have that reaction for all law enforcement investigations. That would provide a lot of collateral damage in non-abortion relevant proceedings. How can companies tell the difference? Well, one answer is that some jurisdictions require law enforcement, including the feds, require law enforcement to state the statute allegedly violated when they serve the warrant. But another solution is that in companies themselves, they have the means to incentivize greater disclosures from law enforcement about what their warrants are seeking, what type of investigation is at issue. Right now, major technology companies have online portals that provide efficient, hyper-efficient access to law enforcement for serving legal process and obtaining data. They do not provide access to those portals to non-law enforcement investigations. So there's already a two-tier system. One thing that law enforcement that companies could do is condition access to the hyper-efficient system on the law enforcement providing an affidavit that it's a non-abortion prosecution. So final thoughts, there are also roles here for legislatures, statutes that you should watch out for that are in existence are the My Body, My Data Act. This was introduced by Senator Wyden, among others, and was the first abortion-specific data privacy act post-Dobbs. It would extend some data privacy protections to entities that aren't covered by HIPAA. The current Health Data Privacy Act only covers traditional medical providers, so it doesn't cover tech companies or apps. And so My Body, My Data Act would extend protections to those entities, and it would require express consent to collect reproductive healthcare data or limit collection to data that's essential for the provision of service. The Fourth Amendment is Not for Sale Act is another act to follow. This one would prohibit law enforcement from purchasing data on the commercial market if the data would otherwise be protected by the Fourth Amendment and require a warrant. So that's not abortion specific, but it would put some limitations on what law enforcement can do. And then the final idea, this one is a proposal that I'm making and is developed further in my forthcoming article with Aziz Hook, that lawmakers should be enacting evidentiary privileges. So I pitched this idea in testimony before the House Judiciary Committee for the US Congress in July, and said one limitation of existing privacy protections is that they yield to legal process. So HIPAA's got an express exception for law enforcement. The Fourth Amendment, of course, you got to get a warrant, but if you get the warrant, you get the data. And that's true of the Stored Communications Act, of other federal statutes, data privacy laws. They are not there to block valid legal process, but evidentiary privileges do. Evidentiary privileges say this information is immune from a warrant, from a subpoena, from a court order. And if somehow law enforcement or civil litigants get access to it, they can't introduce it in court. So it's that type of protection that I actually think we need. Thank you very much.
Great, thank you, Rebecca. Now we're going to turn things over to Matthew Kugler, and let's just get the slide sharing working here for Matthew. Let's go ahead, Matthew.
Great. Thank you, Dan. Thank you, Rebecca, for starting us off with that. I'm going to be talking about a different kind of surveillance that also poses problems. So the kind of surveillance Professor Wexler was talking about is the kind of surveillance you get with legal process. Companies are collecting information. The government at various levels wants to get that information. They are filling out forms. They're going to court and getting court orders. they're not generally paying money, and they're actually not paying a ton of time. They can do this at bulk. The kind of surveillance I'm talking about is quite different. It doesn't involve the cooperation of the courts. It doesn't involve the cooperation of, say, the local state government. Another major problem, California has views about its companies complying with out-of-state warrants. There was some legislative action on that about a week and a half ago. But realistically, anyone can show up with a camera. And apparently that's not. Cool, there we go. So if you look at these, the date on the one on the right here is 2001. The other date's 2022. Basic idea. There is a long history of people putting cameras opposite abortion clinics. This is done for a variety of reasons. Clinics themselves do it to monitor protesters, secure the site. Protesters do it to identify doctors and employees and also patients. And protesters also do it sometimes for an intimidation factor. Chatting with an activist back in the early 2000s who said, yes, there is a camera opposite that clinic at all times, but half the time there isn't a tape in it. Because at the time you needed a physical tape. And honestly, VHS tapes, very awkward way to run long-term surveillance. That is not how we do things anymore. And now that we're moving into the new post-Dobbs era, the thing people are talking about is facial recognition, artificial intelligence, object recognition, license plate readers. So how does this come together? Why might this start mattering? Well, imagine that you live in Indiana. You want to go to Illinois for an abortion. Maybe you want to call up someone and get their help to get there. That person might be part of an organization that regularly does this. What is going to generate? Well, a car with out-of-state plates is going to be pulling up outside of an Illinois abortion clinic. It's going to be doing it repeatedly. It's going to be really easy to get the license plate of that car. If that person is not wearing a mask, it's going to be really easy to get a photo of their face, and given off-the-shelf facial recognition technology, relatively easy to identify that person. And as you saw on Professor Wexler's map, Illinois is kind of surrounded. Like, oh, Northeast, you're not crossing a lot of borders in the Northeast to get an abortion. It's fine everywhere. West Coast, states are big. It's going to be hard to move around. Illinois, oasis, surrounded by a desert. And so what's changed after Dobbs is what happens with the data from these cameras. It used to be that, yes, you could identify who was getting an abortion. You could identify the volunteers at the clinic. You could identify social services that are helping people get to clinics. But all of this was just legal. Like, oh, yeah, you drove someone to an abortion clinic. What's the big deal? Good you. Now, some states have views about this. And the idea of crossing a state border to get an abortion is something we're still trying to figure out how legal that is. So here's the basic problem and why I'm actually a little skeptical we can do much about this. There are things we can do, but they're hard. It's generally lawful for Sergeant Smith to stand on a public street and look around. It's generally lawful for Sergeant Smith to do that and take pictures of what he or she can see. It's generally lawful for Mr. or Mrs. Smith to stand on a street with a camera and take pictures of what they can see. We're not going to change that. So yes, you can do that. Highly private places like, say, abortion clinics need to have publicly accessible entrances. And in places where they've had a history of protesting, you have things like fenced off parking lots with one entrance, trying to make it so you can easily secure the site. But it's constantly a race between allowing people to get in when they want to get in and not allowing the wrong people in. And the more you kind of hunker down to one entrance, the easier it is to monitor the entrance. So long as you're not doing this with pills sent through the mail, people have to show up at a place, you can monitor the place. And video technology has come a long way since the 70s, a long way since, say, 2001. Now you can store dozens and hundreds of hours of video without a problem, Now you can do automated object recognition to read the license plates. And now you can generally do facial recognition. The laws on these are not particularly helpful. License plate readers are just generally legal. There are some states that have like law enforcement reporting requirements. Let's see what you're doing with these. Those laws, as far as I can tell, are generally ignored because no one actually cares. This just was not a major issue. So yeah, you can go buy those and just track license plates. Facial recognition is banned by some municipalities for government use, but not by any states that I'm aware of. And in private use, it's only regulated in a couple of states. And this is something that could change. But at the moment, there would be nothing stopping an Indiana police officer from walking into Illinois, taking a lot of pictures, walking back to Indiana and running facial recognition on them. I don't see any legal problem with them doing that. And you could do things to try to change that. You run into an awkward mess of immunity issues where you try to regulate the actions of people working for other states. But by and large, we're in a lot of trouble. As those of you who have been in my privacy class know, private use of facial recognition, we call it bounty hunter statutes that Professor Wexler alluded to, is only really banned in a couple of places, or rather heavily regulated to the point of being banned. Illinois is the only one that has a law that actually does much on this. That's kind of great. Having said that, it is really hard to know what happens when you take the picture in Illinois, walk across the border to Indiana, upload it in Indiana. And you're going to run into a massive awkward jurisdictional issues with all of this. And so as I'm looking at this, I see a large opportunity for conventional shoe leather surveillance practices to generate dangerous data. And there's only so much you can do because people still exist in the physical space. And we'll see what happens over time. I could imagine investigative measures and countermeasures having a bit of a back and forth on this. Maybe now clinic escorts show up masked. Maybe now people who help people get to clinics show up masked. It's not how they've generally done things. Generally, it's like, oh, I'm an escort. Part of what I'm doing here is I'm showing this is normal and okay. I'm showing I'm not afraid to reassure the patients. But that's a trade-off and maybe one that's now a little bit more dangerous to make. And the license plate thing, I think, is going to be a problem for anyone who's trying to organize repeated rides. Because you're not going to take an Uber across multiple state lines. That's just not going to be a thing. Would people volunteer to drive that car? Yes. Will that person now be relatively easy to identify? Also, yes. So we have some consequences there. So thank you guys. I look forward to Christina's remarks.
Thank you, Matthew. Okay, Cristina, let's stop sharing the slides on this side and
All right,
turn things over to you.
wonderful. Okay. Here we go. Does it look okay?
We don't see presentation. There we go. Perfect. Looks great.
All right. So hi, everyone. Apologies for the FBI witness protection program like lighting. I'm speaking from a hotel room that has a really odd lighting from all angles. So apologies for that. I'm going to take us in a little bit of a different direction, although everything that I am going to say actually very closely relates to what Professor Wexler and what Professor Kugler have already talked about, which is what we are seeing here in the US with respect to what is happening to privacy post-Dobbs, and how is that going to influence the way the outside world sees us, and why do we care? So let's go to that one. A couple of years ago, I should say maybe a year and a half ago, we had a very famous case that came out of the European Union, and it was the Schrems 2 case. And for those who have been, playing in the privacy space, for those who are learning about privacy, this is certainly something that you would have heard about, certainly something that made a lot of waves. And the reason it made waves is because it was a case that essentially took down what used to be the main cross-border transfer mechanism for data from the European Union to the US that was called the Privacy Shield. The Privacy Shield was rendered inadequate. It was, the rumor has it that they're now working on Privacy Shield 2.0. But as of right now, we have all of these companies that did all of this work to be Privacy Shield certified, and now they can no longer use that mechanism to transfer data from the European Union to the US. And so they have to use other mechanisms. But the big point about that case was actually the second part of it, which was that European authorities, the European Court of Justice, deemed the United States to be inadequate due to the fact, inadequate for the protection of personal data, I should say, not inadequate generally speaking as a jurisdiction, although, who knows what they think about that. Inadequate with respect to the protection of personal data because precisely of exactly what Professor Wexler and Professor Kugler have been talking about, which is the US government's access, ready access, easy access to personal data about individuals. The Schrems 2 case was focused on really a statute that is, I think, continues to be misunderstood in the US and is definitely misunderstood outside the US, which is FISA 702, right? So the Schrems 2 case really focused on FISA. But the point that I want to make here, right, is that we had this big shot that was heard around the world that focused on the fact that the US government cannot provide adequate protection because the US government has access to too much data or can get access to too much data about individuals. What has followed since that case has been for private companies, and again, as was I think was mentioned in my intro, right? I'm an attorney with Baker McKenzie, and so I advise private companies, I advise multinational companies. What has happened following that case is that it has become truly significantly more difficult to transfer personal data from the European Union to the US due to these additional adequacy measures that need to be put in place, whether they're technical, whether they're organizational, whether there are these things called transfer impact assessments that need to be put in place, right? Because of this core concept that we're talking about here, that has and that has gotten progressively worse, I would argue, post-Dobbs. We have a recent memorandum, just to give another example, that was written for the Dutch Ministry of Justice that essentially eviscerates, and again, misunderstands it partly, but eviscerates the Cloud Act to talk about how the Cloud Act really makes it easier for the government to have access to data, to personal data about both US and foreign citizens. On the other hand, in the US, putting Dobbs to the side for just 2 seconds here, right? What we like to be thinking about in the privacy community is that we are generally trending a little bit more toward privacy, right? Look at us. We now have the CCPA and CPRA, right? We have other state privacy laws. We have Virginia, Colorado, Utah, Connecticut. We're going to see in the next slide that we have a federal law potentially on the books, although I think as of yesterday, it's encountered some sort of difficulty in the House that I have not quite dug as much into as I would have liked. So there's this continued tension between the US and the international community of how much protection we think we afford to personal data and how much protection the international community thinks that we afford to personal data, right? And this has not, Dobbs has not yet become an issue of discussion to my awareness overseas, but in my prediction, it surely will. As I mentioned, we have a federal Privacy Act that is drafted. It is on the books. Whether it provides protection that would lessen the concerns of the international community, whether it provides protection to personal data, is a big question mark. We have the FTC, and I think Professor Wexler mentioned one data broker. I'm going to mention another data broker. So this was an FTC enforcement that I think is hot off the presses, maybe from a week ago, where there was another data broker, Kachava, and they were collecting very sensitive geolocation data, and particularly geolocation data as related to health and other sensitive matters. And so the FTC, following Dobbs, has made a commitment to really go after these types of companies that, again, I think it was Professor Wexler who mentioned, that are not regulated, that are not otherwise regulated by HIPAA, right? So HIPAA regulates covered entities and their business associates. HIPAA does not regulate health apps. HIPAA does not regulate, certainly, data brokers, right? So we don't have a mechanism to regulate these potentially these entities that do collect a ton of sensitive personal data about individuals that then, right, post-Dobbs can now potentially be shared with the government. In the US, we have enforcement by private litigants. You know, California is not one of the Dobbs, you know, state of concerns. But I think, to Professor Kugler's point, who knows what we will see with respect to traveling to certain states, right, to get an abortion? Who knows what we will see with respect to other things you might do in other states while you are a resident of, you know, Indiana, for example, traveling to California for different reasons, also tied to privacy. And I do anticipate that all of this, so this is the culmination of what I wanted to talk about, which is the last bullet here, that we will continue to receive incredible scrutiny from European data protection authorities. And depending on how we respond, depending on how the world starts seeing us as the country that not only, you know, we have this neat little statute called FISA where the government can potentially collect data, but now we potentially have the government being able to connect the most sensitive, I would argue, data about us. And will that mean eventually, right, that we have a situation where the world sees us as completely inadequate for transfers of personal data? And what that will mean for doing business is a, you know, probably something that I could speak about for an hour, and something that would put most of my clients in, you know, a permanent state of panic. And quite frankly, you know, even if you're not thinking about the private sector, should probably put everyone in a state of panic, because everything that we do and the business of running so much of what constitutes our lives is made up of the transfer of personal data, right? So were that to be impeded in any serious way, right, we would have significant concerns, I would say, significant difficulties. So with that, I think my time is up by my clock, and I'll hand it back over to the room.
Great, thank you, Cristina. And I'll welcome Matthew to come back up here and join us. And there's hopefully what we can do is in this hybrid format, try to have a good discussion among the panelists. So we've got a few questions on Slido. I wanted to ask a quick question to just help kind of set this. So these are all great kind of like lightning talks, touching on a lot of different things. I'm wondering if, and we'll start with Rebecca, and maybe everyone can kind of opine on this, but where are we most likely to see practical problems? Like people are going to really experience issues here in getting, getting care or helping people across state lines or things like that, versus to what extent are some folks might be thinking like, these are law professor hypotheticals, like, but what practically speaking are we already seeing, and what are the worst fears kind of what could emerge? Rebecca, do you want to speak to that a little bit, just to kind of ground us on all this?
Sure. There's nothing hypothetical about these risks. As I mentioned, there have already been criminal prosecutions pre-Dobbs based on data from web search histories and text messages. And post-Dobbs, there have already been criminal charges based on Facebook communications contents. So I think that Professor Kugler's point about the collection of various types of data, identifying data, face data at location sites shows how many sources of evidence there are to support these vigilante civil suits and criminal prosecutions. But there is nothing, I mean, the most extreme that you can imagine is happening. There were prosecutors in Texas were threatening the partners of law firms because of their policies to provide free travel and relocation expenses for employees seeking reproductive health care. So there's no limit on what anti-abortion activists will do. The only limits that we can hope for on protecting data are going to come from corporations and law.
Matthew, you want to share your thoughts on that?
We have a lot of uncertainty, and it's really bad when you stare at a criminal law and say, I don't know what's legal. I don't know whether a state can criminalize traveling to another state for an abortion. The answer was certainly no 6 months ago, but then again, a state couldn't criminalize abortion 6 months ago. So I don't know what that answer is. As Cristina was pointing out, we generally have an assumption that law enforcement, given a valid warrant, should be able to get access to basically any bit of data. And we were sort of okay with that when we agreed that the things that were prohibited by the criminal law were bad. Now we have a very salient and widely applicable example where there's dispute about that. And so that's really, really awkward. And it's making us just wake up to how completely screwed up privacy law is in general. Like, none of the problems that any of us mentioned are new. It's just that in this new context, they're so much worse than they were before. Like Professor Wexler has been writing about the rights of criminal defendants and government having too easy time getting data, defendants having too hard a time getting data. That's been going on for years. I've been writing about my issues for years, complying with the various statutes. Cristina's work at Baker McKenzie, that's been going on for years. None of this is new. It's just that now it's going to be producing tragic stories day in and day out. And honestly, we're really just limited by the imagination trying to detect this stuff.
Cristina, you want to add your thoughts on that?
Sure. No, I mean, I think that's exactly right. And one of the points that, I said very briefly that, with respect to the international perception of us, right, that FISA is misunderstood. And the reason I am not by any means a FISA expert, but I do know enough to be dangerous and enough to be able to speak about it in the privacy context. And one thing that, we can say about FISA, right, is that it does have it does have a whole bunch of rail guards around it, right? So we have the FISA court, right? We have, there's this misconception that these FISA warrants are just out there sort of floating around in the ether and being granted, and there's this whole bunch of access to data, and that's just not the case. And so I think exactly to Professor Kugler's point, right, there's just the uncertainty is tremendous at this point, because we have this one case and now we have, havoc, right, where we don't have these fairly well thought through, I would say rail guards, right? That will protect how the government gets access to data, when they get access to data, what kind of safety net will we have to ensure that data is processed, to take it back to like privacy 101 principles, the minimum amount necessary, right? So data minimization and collection and all of that. Like there is nothing here. We are dealing with the Wild West in terms of what we're looking at and what we're looking at for the future. And I think that Professor Wexler also made a great point with respect to private companies, right? And I think where this is going to be really interesting, and I've already started seeing it with a whole bunch of my clients, is privacy is becoming a good thing to go to market with, right? To be the privacy friendly company has worked for certain companies that I think we all know and love, and we probably use their products every day. And it's increasingly going to be a good thing to position you in the marketplace, whether it's in this context, whether it's in any other context. So I do agree that the private companies will have a big role to play here, for sure.
I'll just jump in and say, to add to the point about state boundaries and cross jurisdictions are not going to protect us. The first prosecution under SB 8, the Texas vigilante civil suit, was brought by an out-of-state plaintiff voluntarily against an in-state provider. But there's no limitation written into these laws that says that they can't apply across borders. And there's no reason to think that anti-abortion plaintiffs or prosecutors are going to try, are going to respect state borders. In terms of accessing data across borders, if we don't have data privacy laws like Cristina is working on, we don't have an evidentiary privilege. Most states have enacted this thing called a Uniform Act. There's a criminal version, there's a civil version, and it is basically a commitment of state courts to cooperate with one another across jurisdictional lines. Now, data stored in one state, the courts have some discretion to refuse to enforce an anti-abortion warrant, but it's not a ton of discretion and a privilege or state statutes that prohibit or carve out abortion-related data from the Uniform Act would help those courts not comply.
Yeah, the thought I was having to Christina's comments is that Microsoft for a while tried to compete on a privacy level with Google, and that didn't work very well for them. And that was in a particular social reality, and now we may be in a very different social reality. But privacy means so many things and has so many degrees. Getting a good press release and a good headline on privacy may be a lot easier than actually protecting the privacy of your consumers, particularly given just the feast, the excess of data collection we've been seeing over the past 2 decades from American companies. The amount of improvement we need is so drastic. For the two of you, did either of you see what California was doing with Professor Wexler's last comment about abortion-related data? I think the legislature passed something a week and a half ago. I don't know if the governor signed it yet. Have you seen that?
I have not seen it. Please tell me. I'm excited to hear about it.
I assumed you were going to be talking about it, so I was like, oh, I'll leave
Sorry.
that. Sorry. One of those things where something's so relevant to a person, you don't send it to them, just like, oh, 10 people must have sent it to them already. But yeah, so California was trying to pass a law basically saying that if you're trying to do a data request for abortion-related, well, if you're doing a data request of a California company with an out-of-state court order, you have to certify that it's not related to an abortion prosecution. There were details. I don't believe the governor has signed it yet, but this is sort of like hot off the presses a week and a half ago, the legislature was passing this. So I was talking to Professor Wexler a few weeks ago saying, oh, I mean, surely we're going to see a breakdown in comedy between states in terms of enforcing each other's warrants. And yes, we're seeing that in real time. Everything is being done quickly. I imagine things are being done in an ill-considered way. We are going to have loopholes. We're going to have oversights. We're going to have overbreadth because no one was really prepared for this, as far as I can tell.
Well, with this discussion about whether we can rely on tech companies to kind of stand up for privacy is a great question. And there are a couple of questions in Slido here that I hope we can talk about a little bit more. Rebecca, I think you talked about this. I'll let you take the first crack at this. But so there's two questions. Does Google have a definition for which sensitive sites for which it won't be logging location data? And then the questioner points out the same issue could apply more broadly to other sorts of healthcare data. And then this question of, could Google's deletion of data, and of course, that'd be different than just never collecting it in the first place, presumably. But could deleting data about abortion be seen as an illegal behavior?
So Google has actually made this promise for a list of different types of sensitive location information. I'm not sure that they define what is an abortion clinic, but their promise extends beyond abortion clinics to other doctors, other health providers, again, domestic violence sites. So it's not limited to abortion, and they've characterized it much more broadly, as you anticipated. Would deleting data subject them to criminal liability if there's a court order that requires that they preserve the data, or if they can anticipate that the data is going to be subject to a particular ongoing litigation, then yes, that would be spoliation. But until that happens, no, they could delete whatever they want.
Okay.
Good question.
Cristina or Matthew, anything you want to weigh in on there?
Go first.
I would just add, I think that's exactly right with respect to the deletion of the data. And I would just say that one point that I think the big tech companies are going to be, and all companies really that collect this type of data, that they're going to have to align on, right, is what promises, right, they have already made and they make to consumers. And then where we're looking at these state laws, right? So California is a great example because all the tech companies, have some sort of California data, right? What promises have you made? And then also what obligations do you have to hold on to the data, to delete the data, to not sell the data, et cetera, under, laws like the CCPA, CPRA, right? And so I think that's exactly right. But the issue with respect to how companies, and again, I'm coming from the private perspective of how companies will really operationalize this and how they can make an honest to goodness effort to operationalize this, I think will be the real challenge here for sure.
To go back to something Professor Wexler said at the beginning, it doesn't matter whether in some macro sense, Google could probably figure out that it deleted data showing you went to an abortion clinic. Because Google is not being asked to give a list of people who went to an abortion clinic, use your best effort to determine it. They're being asked to fill a particular warrant. And if that warrant is for people who were within this exact geographic area, and Google can say, we don't know, then Google is done. So it's not Google's active help in a computer science sense could you possibly get from A to B. It's what court orders are they getting, and do they have the information to answer them in a revealing way. So the problem is not as bad as it might be in that sense.
So the most upvoted question that we have actually on the site right now is a question, I think this gets to some of the things you were talking about, Matthew. Do we need to rethink the assumption that law enforcement should be able to get access to any data? Investigations were just as important back in the day, yet there were limitations in place limiting overly broad or unreasonable searches.
Well, the problem is the search is not overly broad. Like, hey, if it's illegal to go from Indiana to Illinois for an abortion, and I can show that this person did that, that's fine. Now, you could say that something like a geofence warrant is generally not constitutional. There has been some discussion in the courts on this. Can the police get a warrant for the number of every cell phone that was within 100 yards of this crime site? I see arguments both ways. If the crime site's a murder, though, I think generally, yes, you should be able to get that list. So there's a question of is the problem the substantive law or the procedural law? I think the problem here is the substantive law. It's that this thing that some states say is a crime, I don't think should be a crime. So it isn't that law enforcement is just generally so good. It's that I don't want them to be doing this at all. But yeah, if you're looking for Fourth Amendment case law on this information is so private, you can't get it with a warrant, it's things like therapy notes in some states. You can't be made to like undergo surgery to have a bullet removed from you. There's that one case every casebook cites. But by and large, you're running up against a very small number of evidentiary privileges, which is really Rebecca Wexler's primary area. So do you want to chime in there?
Well, I love privileges. I think privileges are fascinating and they are so powerful, just as Professor Kugler is saying, privileges can actually block warrants. So if you want something that says this is off limits to law enforcement, give it a privilege, like your attorney-client communications. If law enforcement somehow sweeps those up in a search, a warranted search, a lawful search, they have to purge the information and have a taint team to make sure it doesn't get to the prosecution. So there is information we say absolutely off limits to law enforcement, but we have to do that with a privilege. Now, Professor Kugler brought up a point. If you were going to try to constrain law enforcement to that extent, extraordinarily powerful limitation on law enforcement, what are going to be the collateral harms? Is it going to impede a murder investigation? So in terms of the privilege proposal that I mentioned in this presentation, I have been working with, this person is confidential, but a member of Congress who followed up on the testimony to develop such a bill in a federal in the federal Congress, and also some folks in Illinois governor's office who are interested in a state version. And the solution that we've come up with to try to minimize collateral harm from enacting a privilege is to give it a very broad definition of data that it would cover. So huge amount of data that would not be available to law enforcement, but only have the privilege apply in anti-abortion proceedings. And that way, it wouldn't have any effect on the murder investigation, custody disputes, domestic violence, medical malpractice lawsuits. Abortion relevant data could come up in many of these contexts, and the privilege could be all powerful, but it have this extremely narrow application. So that's my proposal.
Thanks, Rebecca and Matthew. Cristina, let's start with you on this next question. So Dennis Kennedy asked whether anyone's willing to predict whether we'll see new comprehensive US federal data privacy laws in the near future, or are we likely just to continue sliding towards 50 different state privacy laws? So what do you think? Where are we at? Is there reason to think this time is different?
So I think I've had this, and I want to hear from Professor Kugler next, because we've had this conversation many times about how optimistic or pessimistic each of us are. I happen to be, I don't want to say by nature, because I'm not by nature a pessimistic person, but in this case, I will believe it when I see it. I don't, the preemption issue, which is, I believe, what is actually getting hotly debated in the House right now, is a big issue. And so we have, what I mean by that is we have, right, this new law that has, part of it has come on the books already, the CCPA. We have the CPRA that's coming, that is supplementing it and revising it. It's coming into effect January 1st, 2023. Companies have done tremendous work to comply with this law, the first of its kind in the US. And California takes tremendous pride in this law. Several states have followed suit. And so preemption is going to be a big thing. And the reason this makes me very pessimistic, right, is because the reason for having a federal privacy law is exactly to preempt these little tiny state laws from actually wreaking havoc in the privacy world, right? So from preventing something like what we have in the data breach context, which is totally outside what we're talking about here, right? But when a company with employees, for example, in 50 states has a data breach that involves everybody's social security number, you have to look at.
Oh, we lost Cristina. She is joining us from Europe actually at this time, but so Matthew, do you want to jump in?
So, well, Cristina mentioned in her talk.
Yeah.
Oh, looks like Christina's back. So, okay.
Do you want to?
Oh, goodness. Was I just talking?
For just 20 seconds, probably.
Okay. Well, I don't know where I left off. My apologies.
How would I just,
Yeah.
I think you said most of what you were trying to say there. One thing Christina
Okay.
mentioned that I had not been aware of is Nancy Pelosi. So California has this really strong privacy law. Companies have been tearing out their hair over it. Companies have been spending lots of money to comply with it. Christina has been hiring our alums to help with that. So yes, thank you, Christina, for doing that. The problem is this new federal statute would need the votes of Californians in Congress to pass. So those people who are a necessary part of the pro-privacy coalition have been making noises about, please don't preempt too much of our state privacy statute. And at the same time, the only reason why anyone's willing to go along with the national privacy statute is the idea that we won't have to deal with all this mess across 50 states. So it was kind of weird that the law currently being proposed had like gone through a House committee. Like, wait a second, like what's happening here? And it's like, oh, the White House is pushing it. Some people in Congress really want to simplify this area and have a unified statute. Nancy Pelosi yesterday apparently made some noises about not liking the current draft of the bill and not being able to support it in its current form, which could be a negotiating point, or could be, no, this bill is dead, you're never going to see it again. We don't know. My thought is that we will get a unified privacy statute at the federal level if the Democrats hold Congress in November. If they hold Congress, then sometime in the next 2 years, they'll sort it all out. If they don't hold Congress, this isn't happening for a while. Just because you need time to negotiate this, I don't think we have to.
Rebecca, your thoughts on this question?
Hopeful, but I'll see. I'll believe it when I see it.
Okay, another question we got actually from one of our friends in Europe, Veronica Mocano, asked, what do the experts think regarding the possibility of bringing to the US legislation similar to the GDPR right to be forgotten? Is anything that's being proposed right now look like that? And what's the possibility of seeing anything like that? Matthew, do you want to jump in on that first? Or
The closest thing is the right to delete in the CCPA in California. It has so many exceptions. I don't think it's fair to liken it to the right to be forgotten. Constitutionally, there are limits to how far you could push this in the US anyway. Cristina, you're more in the nuts and bolts of this though.
I think that's exactly right. And my apologies, I'm being told my internet connection is unstable. So, but much like the CCPA, so there.
okay, so we lost Cristina. Rebecca, we have a question here that's been upvoted a bunch of times from Donna about the implications of the government itself buying data. So they're saying the FBI, Department of Defense, Homeland Security are purchasing cell phone location data. Could you just talk a little bit more about like what current checks are in place on government agencies purchasing data?
So currently there are no checks in place or very few checks in place on government agencies purchasing data, for instance, cell site location information, despite the fact that the Supreme Court in Carpenter said this information is protected by the Fourth Amendment. Now, from a broader perspective of criminal investigations, there's nothing unusual about the government purchasing relevant evidence from the private sector. They hire confidential informants, they give rewards for tips, they pay for evidence all the time. So there's not a shock there at all. And that includes Fourth Amendment protected content. So if you would need a warrant to go into somebody's house and search and seize, but you give a reward for an informant who has seen something in somebody's house and wants to tell you over the phone, you're getting that information another way with the money. There is some precedent, however, for limiting the government from doing this. The Stored Communications Act prevents certain technology companies that provide electronic communication services from voluntarily sending information to the government, and that includes voluntarily selling information to the government without a court order. So there's precedence in either direction. That's the existing Stored Communications Act limit is the only one that I'm aware of. But certainly the mere fact that information is protected by the Fourth Amendment does not stop law enforcement from purchasing it from a willing informant.
So we've got just 1 minute left here. Now, maybe we can do kind of a speed round on the last question here that was kind of upvoted. So we've alluded to this view of the rest of the world, of the US as kind of being the Wild West. And someone raised the question that with emerging state privacy laws, is that view maybe inaccurate to some extent? And if we're not going to have comprehensive law, maybe these different state laws provide more protection than folks might realize. But Cristina, you want to jump in on that first, and then we'll go to Rebecca?
Sure, and I think it is unfair in some ways, but I do think that, and what I was apologies for starting to say is I completely agree with Professor Kugler's statement that, for example, for the right to delete, the exceptions swallow the rule, and I think a lot of these state laws actually have a lot of carve-outs, a lot of exceptions, so it might not be entirely unfair to say that.
Yeah,
My
thank
last
you.
And I'm going to defer. Christina and Professor Kugler are the experts on that one.
Matthew.
I mean, the state laws are wild. Like BIPA, the biometric privacy law in Illinois, is certainly wild. It is very protective, but it's also completely insane. And if you try to actually understand the California privacy law, there's a lot of protection there, but there are also giant loopholes there. And most of all, no one really knows what a lot of it means. So if you're comparing this to the comparatively well-ordered GDPR, and Cristina, I'm sure, has views on how well-ordered GDPR is, we are not there.
Okay, well, thank you so much for a great discussion, great conversation. Thank you, Cristina. Thank you, Rebecca. Thank you, Matthew. Thank you also to David Scheckman and Elise Wu for helping organize this. And thank you for everyone for attending.
David. Thank
All
you,
right,
Elise.
take care,
Thank you,
everyone.
Dan.
Okay,
Thank
thank
you,
you.
everyone.
Thank you. We look forward to
Thank you
seeing you
much.
all again soon. All right, take care, everyone.